lord, if I have your lordship's indulgence to connect an additional affidavit, my lord, to item number 35, the motion, my lord.
Item number?
35. It's a motion item, my lord. Supplementary motion, my lord.
The affidavit is on record, I suppose.
Oh,
Oh, no. Affidavit is in the other one. You're mad that other.
Ananta Kumar.
Ananta Kumar.
That is an orders column today, my lord.
Oh, you want to have an affidavit, additional affidavit here?
Yes, my lord.
Ananta Kumar Sharma.
84th, 85th BOM proceedings, my lord. They provided us the details only yesterday, my lord.
But what is here? The committee is constituted as per the orders of this court. This court did not direct in either of the proceedings to proceed as per regulation 90. They are proceeding by regulation 94.
The Supreme Court, my lord, had directed.
UGC, that's again a very vague. How?
Because
Supreme Court also said rules. Okay, we'll see.
Malala.
But anything to be done should be done because after 2, this court may not be here today.
May I please, your lordship, my lord? Lordship, in item number 39, lordship, we have filed an affidavit in reply, lordship, that record may be called for, lord.
It will be listed along with that.
Play item 39, lordship.
Today it cannot be disposed of.
Lordship, may take up, lordship.
It will come along with the affidavit.
No, lordship, there is some urgency, lordship.
Huh?
There is some urgency, lordship. That
Today it's not possible to dispose.
if an lordship, we have not taken the consent also, lordship.
A call go idea.
Deeply obliged, lordship.
May I please love me? My lord, item number 24, my lord.
50?
24.
24.
My lord, in earlier occasion, my lord, your lordship passed order, the matter may not be taken by your lordship, my lord. My lord, wrongly it has been listed, my lord. My lord, it may be come on later.
It will reach, I'll pass the orders. Did it reach, I'll pass the orders. Yes.
May please, your lordship, item number 26, we have received the affidavit in opposition 2 days back, that is on 5th of May.
Your name?
I Bhattacharya, lordship,
You're appearing on behalf of?
petitioner.
You're not there. You're not.
Lordship, my name is not in Vakalatnama.
You're
My
appearing
name
for
is not in the cause list, but I have Vakalatnama.
Mr. I.
Bhattacharya.
Bhattacharya, learned counsel for the petition. Item number 26.
26.
Submits that he be granted 2 weeks time to file.
3 weeks of time, my lord.
3 weeks time to file a rejoinder to the affidavit filed by the respondents. Prayer accepted. A registry to list this matter after 3 weeks on date 2 weeks.
I submit.
May it please your lordship, with the consent of the other side, I beg to mention item number 3 for an adjournment, lordship. I am for the respondent, lordship.
On the prayer of Mr. On the, you are for the respondent?
Respondent, all the respondents.
APDCL.
Yes, lordship.
Why adjournment?
Lordship, the conducting counsel SP Sharma has bereavement in his family.
That is already over.
Lordship, the final rituals are going to get over on the 11th.
So I'm for a petition of.
Prayer is made on behalf of Mr. SP Sharma, learned standing counsel APDC for an adjournment in the matter on the ground that he is in bereavement. Prayer is not objected to by the learned counsel for the petitioner. Registry to list this matter again on
We were 25.
19. It's a 2019 matter. 19/5/2026.
Lordship.
Deeply obliged.
Yes.
May it please your lordship, with consent from the other side, your lordship, I beg to mention item number 5, your lordship. Let the matter be listed after 2 weeks of
Why?
time. Yes, my senior has some personal difficulty, your lordship.
Okay, fine. It will be called up now. Be there. Let it be there. It will be called up as the first item. Don't worry. Renew your pair then. Yes.
May it please to your lordship, I beg to mention item number 40. Respondent have recently filed an affidavit. We need some time to go through it and file our response if required.
What happened to the Supreme Court matter?
I don't, lordship. Actually, I have to take instruction in this regard.
Contempt matter. You are for?
I am for petitioner, lordship. On behalf of RS Mishra.
A prayer is made on behalf of Mr. R.S. Mishra for an adjournment in the matter on account of personal inconvenience. Prayer is not objected to by the learned counsel for the respondents. Accordingly, registry to list this matter again after 4 weeks on a date 2 weeks.
Highly obliged.
Lordship, in regards to item 27, on the last day, your lordship has called for the records. Those are still awaited. So department has asked for 2 weeks time.
Why?
to produce.
Records are being created or records are already there? I have called only for the records that are existing, but
Lordship.
that would be required to be created.
Lordship, their reasoning is that because of the election, they couldn't process the file.
Not a part matter.
No, Lordship, not a part.
Mr. On the prayer of Mr. A. Ghosh, A.K. Ghosh, learned Standing Council, Panchayat and Rural Development Department, registry to list this matter again on 25/2026. Mr. Ghosh on the said day shall invariably place on record the records called for by the order dated
Chief, that
by the earlier orders of this court.
Your Lordship, there is an interim order that may.
Interim order passed earlier to continue till the next date of listing.
Your Lordship, is it possible to be on 20th of May,
To 2020.
205.
2005?
Ah.
All.
Obliged, Lordship.
Mara. Yes. Your senior is not here. A prayer is made on behalf of Mr.
B Datta, your Lordship.
B.
Datta.
Dr. for an adjournment in the matter on account of personal inconvenience. Prayer accepted. Registry to list this matter again after 3 weeks.
2 weeks, Your Honor.
3 weeks for a date to be fixed by. Yes.
Obliged, Your Lordship. Yeah, please, Your Lordship.
Yes. Who is for? Get somebody from the AG. Their names are not shown. Because they say that the proposal is now pending with the AG.
Yes, sir.
Yes.
We'll get it. Yes, madam. You are appearing on behalf of Mr. B. Chakraborty, AG. Can you have an instruction? No. Next day.
Yeah, next day.
You are there as serial number 12. Miss A. Sharma, learned counsel appearing on behalf of Mr. B. Chakraborty, learned standing counsel AG, bracketed A&E, Assam, shall receive instructions from the respondent authorities, from the respondent represented by her, as to whether the pension proposal in respect of the petitioner has been received complete in all respects and the stage at which the same is being processed. At the stage at which it is pending as on date. Also, the said instructions be placed before this court on the next date of listing. Also, registry to list this matter again on 13/5/2026. Just get that instruction.
Yes.
Reflecting the name of Mr. B. Chakraborty, learned standing counsel AG in the cause list. Actually,
Yes, sir.
if they get it, you get it.
Yes, sir.
Why issue notice pending?
Lordship, I'm appearing
Obliged, my lord.
3 to 10.
Ms. MD Bora, learned
Standing
standing
counsel.
counsel,
Corporation.
Mr. A. Chalia, are present for their respective responses.
Obliged, Lordship.
M. Bhachaji, Potham. MD Bora, A. Chalia, are present for their responses.
Deeply obliged.
May I please, Lordship?
Mm.
This is the cover case, man.
Yes.
For non-payment of the minimum pay.
Covered as in Lordship verification.
That you do it, you come back.
Subject
Mr. Bora, let them do that. Let them come back next day, we'll dispose it of.
to let them verify and.
Oh. Nothing like that. We'll let them do that. Miss B. Bora,
Lordship.
learned standing counsel, BTC, submits that she be granted a week's time to verify the service particulars of the petitioners in the present writ petition, and as to whether they are also covered by the earlier decisions of this honorable court relied on in the writ petition. Also, accordingly, registry to list this matter again on 15/5/2026 for motions. Just for motions only. Then they get it, we'll pass it. So then there is no further problem for this petition. Poor people, why make them come back again and again to this? You get that thing?
Lordship. The pen,
Madam, how can we assume jurisdiction to ourselves in such matters?
yes, your lordship, actually, under some mistaken advice, petitioners approached the labor commissioner.
No, you have still not approached the appropriate forum. This is
That is there.
construction.
Your lordship, kindly see. Kindly
I'm
see.
sorry, no court can assume jurisdiction to itself.
Your lordship,
This is an employee, your father was an employee of NF Railway Construction Wing. Anything is there, you go before the Central Administrative Tribunal. How
your
can,
lordship, but liberty has been given, your lordship. I know that. A special liberty has been given to us. Annexure 1, your lordship. May kindly see.
liberty
Yes,
in
your
violation
lordship.
of statute?
By,
Who
by
gave you?
this, by this honorable court only.
Oh,
By
no, I'm
this-
sorry.
at the-
No court can assume show me the law that I can say that this is under my jurisdiction.
Your lordship is right.
Then-
This is right. This is fact. It's that, but as the,
Why unnecessary proceedings before this court? When you have an appropriate forum.
yes, your lordship.
Okay, you want it on merits to be heard by this court. Ms. Dip, you want it to be heard on merits.
Yes, your lordship.
Show me that your father was a regularized employee. Because compassionate appointment can only be in respect of a regularized employee, a government employee.
Not compassionate appointment.
You want a
Pension. Your
pension, huh?
lordship. Yes.
But he was never regularized.
But the recent case, the Maladevi case in 2025, I have cited it, your lordship. Only 1 year service period is
On the prayer
required.
of the learned counsel for the petitioner, registry to list this matter on 15/5/2020. So you try.
God bless. God bless.
Made to your lordship.
Hmm.
All of the petitioner have approached your lordship.
The petitioner has approached too early.
Malad, that is right. In fact, what happened, Malad, as your lordship may have noted, Malad, there was a regular selection and on the basis of the
But
selection.
you had been, you accepted that you retired under the same kind of circumstances. Now, after retirement, but you are still having around 26 years of service,
My lord.
but they are not giving you pension for that.
No, my lord, the petitioner's claim is that, my lord, since the others were appointed on regular basis.
But
also
that
in the
is,
same
Mr.
selection.
Something which you should have done in 93, 94,
But subsequently, my lord, they have given the regular appointment.
99. Still, you have not come up before this court. You accepted that. Now I think you have retired also.
Yes.
Then?
Only for that, my lord, the counting of that period.
Heard Mr. M.K. Chaudhary, learned senior counsel, assisted by Mr. M. Sharma, appearing for the petition. Issue notice returnable 4 weeks. Petitioner to take steps for service of notice upon the respondents number 1, 2, and 3 by way of speed post. Steps within 2 working days from today. The issue of maintainability of the present writ petition is, however, kept open.
Your lordship may also observe, my lord, the pendants shall not be a bar to, my lord, the consider the representation. My lord.
Okay, fine. Let them. What is that representation? We are now deciding your health, right?
Maybe, my lord, they consider it and my lord pass approval.
When I said maintainability, I should not put. You have waited for so long, wait for a week, 4 more weeks. Yes, madam. What?
Similar lordship.
Hmm?
Similar lordship, direct the authority, direct the petitioners to file their application separately, individually.
This one?
Last order lordship, last judgment.
You want the court to
that
follow this order?
is, yes,
But
lordship.
Mr.
MAI Hussain.
FAI Hussain,
MAI.
MAI Hussain, learned counsel for the petitioner. Also heard Miss D.
D.
Bora,
Bora.
learned standing counsel, Health
Health.
and Family Welfare Department. The petitioners at the outset has submitted that they were engaged as casual workers by the respective hospital management committee oblique society. Which committees under the functioning under the health department. The petitioners submit that since the date of their initial engagement, which had occasion during the period 2011 to 2013,
2007 is also there, madam.
2007 to 2013, between 2007 to 2013, the petitioners have completed more than 10 years of service, and accordingly, they are entitled to the benefit of a minimum scale of pay for the works are entitled to for regularization of their services and or for payment of their wages at the minimum of the scale of pay of the regular post work of which they are so performing. Mr. Ali Jagat, Mr. Hussain, Mr. Gogoi Jagat, Ms. D. Bharat. Lucky same page 161 or 162. Disposal.
Yes. Ali apply.
Where have you completed your education?
My lord, that in that regard, my learned brother, Mr. S.B. Prasad, has been entrusted to pursue the
Huh?
matter, my lord. I have asked my learned brother, Mr. S.B. Prasad, to pursue about that particular question along with some other question, to which
What is this question? It's just a clarification.
Yes,
That's all.
he could not, my lord, make contact with the client, my lord. That is why, my lord, I could not find.
We are not issuing notices here. We are dismissing.
So far that part is concerned, my lord, let me, my lord, give some time.
I
so
will
that
give you time.
Yes, I have
A
tried my
simple
level.
reason, where have you completed
Yes,
your
yes.
matriculation? That much only.
So far that.
Because if you say that you are a domicile of that area,
Yes.
which has been disputed,
My lord.
we find that you have done your matriculation from that
Yes, yes.
place, then maybe something.
Yes.
But otherwise, it's doubtful.
Yes, I could understand, my lord, so far that information, whether that should be, my lord, authentic one. So I could.
So how long will you take? 1 year to get
No,
that instruction?
10 days, my lord.
Huh?
10 days.
4 weeks. On the prayer, Mr. Sharma submits that certain clarifications are required to be received from the petitioner. However, contact with the petitioner could not be established. He prays that the matter be taken up after 2 weeks on a date to be fixed by 3 weeks on a date to 2 weeks. Also, prayer accepted, registry to list this matter after 2 weeks on a date to be fixed by it for motion. The petitioner on the next date of listing shall bring on record his educational qualification and also his educational certificates for perusal by this court.
Ali already.
Lordship, I am appearing for, I am speaking on behalf of K.N. Chaudhary, sir. He is in court number 1. Therefore, for the time being, would request short passover.
Will hear the petitioner. Yes.
My lord, the petitioner before lordship is a professor of my lord KK Handicap University. Once he was terminated without my lord giving any opportunity, that termination order was set aside by this honorable court, and this honorable court directed that you have to proceed in accordance with the rules. Against that, my lord, the university approached the my lord division bench, and division bench said that even without rules giving him adequate opportunity, you can proceed. So we filed a review, my lord, because in the meantime, another case was decided by the Honorable Supreme Court. Relying on that, we filed the review. But then, my lord, the on the ground of limitation and also on merit, my lord, the review was rejected. We approached the Supreme Court. In the meantime, what happened, my lord, pursuant to the order of the division bench, they proceeded, my lord. They initiated the proceeding again, my lord, without following the rules. And an order was passed. And subsequent to that, my lord, the SLP was allowed. Allowed means, my lord, the SLP in effect, my lord, said that it has to proceed in accordance with the rules. Now, my lord, they are issuing notices. A committee has been constituted. And that committee.
In the meantime, you filed a further writ petition before this court.
Yes, my lord.
Challenging the constitution of the committee.
Constitution of the committee and the fact that, my lord, the committee was constituted to make, my lord, objective assessment of my educational qualifications, other credentials. Because, my lord, initially, my lord, the candidates, they were scrutinized by outside experts regarding their eligibility. That having been found, I was called for interview.
No, that is different thing. But now if you come to page 160.
Yes. Yes, my lord.
Now, this is a case filed by you.
Yes, my lord.
Now, if you come to 162, clause 3.
May I read that, my lord?
The last part is directed to reconstitute the committee without there being any member of the board.
True,
Now, if you come to the next part,
my lord.
committee so constitute shall fix a new date, and inform the petitioner and thereafter proceed to examine the explanation, show cause reply of the petitioner, strictly adhering to the direction so issued by the division bench in so and so, including certificates, mark sheets from HSLC to PhD, along with so and so, which he has enclosed with his application for the post of professor. Now, this court had directed the committee not only to examine your reply, but also to examine your educational qualification. Now, what is the other?
Now, my lord, my submission before your worship is that this direction has been passed by the honorable single judge pursuant to the order of the my lord division bench. The division bench order has been challenged before the Supreme Court, and your lordship will read the division, my lord, the order of the honorable Supreme Court. That your lordship finds at page 164.
It says, while we are not inclined to interfere with this so and so, we direct that the disciplinary proceedings may be completed in accordance with law, being UGC Regulation 2018 and Service Rules 2019.
My lord.
Now, if you come to the notice that was issued to you, where is the notice that page 229?
229, right, my lord.
Page 231, 2, 3, fourth paragraph, whereas resolution number.
Last paragraph, my lord.
Where is this? Where do we get the Board of Management in the context of the relevant, in the interest is stated to recommend a special procedure for hearing under rule so and so to be read with so and so, in its meeting held on 14/11/2025. Where do we get this?
Additional affidavit. That is why, my lord, we filed the additional affidavit. I was asking for those documents, my lord.
It has come on record.
Yes, my lord. That was given for subsequent to filing of the writ petition.
Fine. 14/11 is at page
Page 80. What?
88 of the writ petition.
Your lordship is looking for the resolution.
14/11/2025. It is here, page 265.
My lord.
Where is the relevant portion, Mr. Sharma?
Two 277, my lord. Long discussion on the directive issued by the High Court regarding reconstitution of the committee. It was informed that Dr. Jayanta Kumar Sharma, professor.
No, where is that decision of the committee that it will be under 94? Where do I get that?
286, man. 286.
286.
There is no 286 here.
From 286.
It starts from 282, my lord.
282. Yes.
Is done. Two courts are closed forums. Not is it?
The effective part is at 286, my lord.
Okay, let's Mr. Chaudhary.
My lord, in the meantime, my lord, just I'd like to point out, my lord, your lordship will kindly peruse the order of the Honorable Supreme Court, my lord.
We have got it. UGC regulations plus the service rules. And it's a departmental proceeding against it. 90. We got it.
Rule 90 and 94, my lord, because which rules are to be followed, my lord, that is not there. But then, my lord,
94, if they are following,
My
subject to what Mr. Chaudhary would say, there is no requirement of you being involved in the process. This is second proviso to Article 311(2).
two, my lord. But
Nothing.
my lord, the rule 94 has some riders.
No, Rule 94 cannot be attracted here.
That is what my submission.
There is no procedure under Rule 9. Rule 99, second proviso to 311 is something which the disciplinary authority on its own has to do on a satisfaction ground.
That cannot be, my lord, the
It
arbitrary.
cannot be brought here. Let's see what Mr.
That
Chaudhary.
cannot be arbitrary.
Let's see what
Because
Mr.
the
Chaudhary-
riders got those, my lord, there are two aspects. One is the subjective satisfaction, one is the objective satisfaction. So far as subjective, my lord, satisfaction is concerned, that has already been, my lord, in the entire process before confirmation, my lord, before calling me for the interview, my lord.
When Mr. Chaudhary, let Mr. Chaudhary for the respondents be here. We'll ask them why 94. And then let us see how we proceed.
Right.
Yes.
Obliged, my lord.
Thank you.
Please, your lordship. The challenge is to the.
The caveat is there, my lord.
Huh?
Caveat is there.
Caveat. Okay. So first we'll hear the caveat. Then we'll hear the.
Lordship may
petition.
discharge the caveat, my lord.
Oh, we'll discharge. Yes, no problem. Yes, what is your grievance?
My grievance is that, my lord, the entire exercise is being undertaken by someone who is not authorized under the act. Your lord-
Not authorized.
No.
Why?
So, your lordship will kindly see this.
Where is the show cause?
I'm just referring to it. My lord, the show cause is at page 18. It has been the power is vested in the executive council.
You want to give one?
27.
Huh?
27. Your lordship will kindly see 27 plus 6.
No. Where have you raised this point in your before the respondents that this is issued without jurisdiction?
No, as far as the charge sheet is concerned, my lord, it is at the stage of furnishing documents. So my
That stage is over.
no, that I applied for the documents. my lord.
That days is over. You have been given inspection. You have done it on 22/4/2026.
Yes, but then there are your lordship will kindly see the last
What is
page,
more
lord.
left?
In the application before the authority. my lord.
Doctor, if the documents are not given, it's you take a plea, proceed with the matter. That will be a defense for you in the inquiry. How can you insist that these documents must necessarily be given to me? Where is the law
My
to that
lord,
effect?
Your lordship will kindly see rule 9.3.
Huh.
Rule 9.3 says that the authorities are under a responsibility to provide me the.
They have provided you the listed documents. You asked for certain additional documents. They said, have an inspection. We have no objection. You say no inspection, give me copies. Finally, they say that 4 documents, we find it to be relevant, we give it to you. Fine, proceed now.
No, they don't even allow me to take the documents. They say that
You
can only-
cannot, you have to take extracts. And that is what is provided under Rule 9.3 also.
No, that is as far as the documents are concerned. I say that these are the documents, I give them a list, that these are the documents, 29 documents are required.
Sir, Doctor, that is just to pull the matter first.
So, well, your lordship
Delay the
will kindly consider my plea as far as the jurisdiction is concerned.
Jurisdiction, you raise that in your written statement.
But before whom, my lord?
Before the authority who has given it, that's all. If it is, you say that you don't have an authority, if he does not accept, come back. But that has to be raised there first. Yes, what is about the?
My lord, he is not, the registrar is not the party respondent here, my lord.
Kindly see your petition. He is respondent number
No,
4.
no, my lord, it is privately, my lord, by name, my lord, one person.
No.
This registrar is not party respondent, my lord. How, my lord, this, the one person,
Now,
my lord.
now the another aspect of the matter
Who
is
is the authority? There is no, you mean to say
The
that.
registrar is the
it's
appointing
nothing
authority, my lord.
Mr. There is no executive council resolution in this connection.
no, it is the executive council who can do it, not the registrar.
Where do I get that?
Now, that's why I said, look, kindly see 27(6).
6 does not say that.
Kindly allow me to read this clause 6. Subject to the provisions of this act and the statutes, it shall appoint the officers, teachers, office and technical and other employees of the university and define their duties and conditions of service, shall provide for filling of the temporary vacancies. Now, anything that they can do, the power is vested in 27(6) and kindly see 27(10). On the next page, it shall exercise all the powers of the university of which no specific provision have been made in this act or in this statute. So it is either in either case, my lord, since my appointing authority is the executive council, so in either case, it has to be the executive council.
Okay, fine.
Now,
But that plea you have never taken before the authorities. The
My lord, I
only
can-
plea before the authorities is that the documents are not being furnished.
my lord, I can take the authority of jurisdiction only if, my lord, he is an authorized party in this case.
Not satisfied.
Now, your lordship will kindly see this gentleman who is holding the charge of registrar. He has joined the office on probation 6 months back. And how can he exercise, being a probationer, how can he exercise some statutory power? Leaving aside, my lord, that question.
Mr. Is it a question of an in charge exercising powers?
Yes.
Disciplinary powers,
Yes.
or a person, although they not empowered to do
Both ways. It is, first of all,
Okay,
my
we'll
lord,
examine that.
first of all,
But
my lord,
you file your reply. We'll examine that.
Well, yesterday is the last date, my lord. Yesterday it was last date.
Last that we'll extend it.
Yes.
We're extending it for you. A week's time, file it, we'll consider everything. No, I'm sorry. Disciplinary proceedings like this will not.
but your lordship will, my lord, if I am
Okay,
to
where is your plea in the writ petition with regard to this maintainability of the jurisdiction?
para 9, page 11.
Nothing can be more vague than this.
My lord, I am referring to the act, my lord. The acts, your lordship will kindly see the power of the registrar is also.
As Dr. Learned Senior Counsel, assisted by Ms. I. Das, Learned Counsel for the petitioner. The petitioner in the present proceeding has presented a challenge to the issuance of a memorandum of charge dated 24/3/2026 to him. The said memorandum is challenged amongst others on the ground that the same was so issued without jurisdiction. Also, the petitioner had, upon receiving the said memorandum of charge, approached the authorities praying for being furnished with documents which he claimed to be relevant to the charges framed against him. The said documents, however, were not furnished, were not provided to the petitioner. All the said documents were not furnished to the petitioner. However, inspection of certain documents, in addition to the listed documents, was provided to the petitioner, which he has also carried out. Also, accordingly, the issue of jurisdiction, the issue of jurisdiction to issue the impugned memorandum of charge against the petitioner would require a detailed consideration. Also, however, the petitioner to file his written statement within within 15/5/2026. Also, Mr. S.K. Medhi, Learned Counsel, appearing standing counsel, Rabindranath Tagore University, shall receive his instructions as to the issue raised by the petitioner in the present proceeding, as to the jurisdiction of the issue of jurisdiction raised by the petitioner in the present proceedings. Also, a registry to full stop. We are not issuing a notice at this stage.
My lord, your lordship will only consider section 16. I have shown to your lordship section 27, your lordship will kindly see section 16. The powers of registrar are delineated therein. Nothing more, nothing beyond. There are only in section 16, there are only 6 clauses, 7 clauses, my lord. These are the limits of his power.
We'll see.
My lord, 4 point.
Oh, we'll see. You get your complete instructions.
No, my lord,
Then get your instructions. To answer. Registry to list this matter again on 25/2026.
My lord, 28, my lord.
No, 20. He'll file his reply. Keep it on record. Don't proceed thereafter. Come explain this thing and then we will pass necessary orders.
Your lordship may make that observation that thereafter they will not.
That they will not do.
No, my lord, your lordship may, I am saying it for some purpose, my lord. Your lordship has taken note of the kind of way, my lord, in which they have been
I am
proceeding
not
against us.
happy with the conduct of your petitioner. He is a true bureaucrat to the core of it.
No.
He knows how to delay proceedings.
No, my lord, it's not about, my lord, I am only taking a plea which is based on these provisions of the statute.
Registry to list this matter again on 25/2026, on which the prayer for admission of the present prayer for interim relief of the petitioner prayed by the petitioner shall be taken into consideration.
Well, the second petition is concerning the suspension.
Along with WPC number 2411/2026. Suspension is only not even 3 months.
Not 3 months, but it is based on the similar ground.
Okay, fine. But you submit your written statement by 15. You take all your pleas there. Then we will see.
Publish.
Sorry, my lord.
No, it's okay, Mr. Chaudhary. Mr. Chaudhary.
Yes.
The sum and substance of all the proceedings before this court, before the Supreme Court, is that there has to be an inquiry in the matter. You have not taken a plea that it is not reasonably practicable to hold an inquiry.
It's not 2, it's 3.
You have not taken that plea.
No.
So now let us see 94, because you have used the power under 94, 2 and 3.
Yes.
Let us see 94, 2 and 3.
My lord, it's quoted in the order.
No, it's okay. It's okay. We have the rules also.
I have the copy of the rules.
No, we have, it is next year.
Additional affidavit come here. Oh, yeah. I can bring this ahead. Page number 285, my lord.
223.
No, 285, my lord. They have annexed, now they have filed an additional affidavit.
No, the rules are there on record.
Okay.
It's at page, it starts, the relevant is at page 222.
Yes.
So,
page number 222. Special procedure in certain cases. Notwithstanding anything contained in Rule 88 that prescribes how a DP will be conducted, where a penalty is imposed on an employee on the ground of conduct which led to his conviction or a criminal charge, we are not concerned.
okay.
Where disciplinary authority is satisfied for reasons to be recorded in writing that it is not reasonably practicable to follow the prescribed in the said rule. This is also not invoked. Now, this is what has been invoked. Where Board of Management is satisfied that in the interest of university, in which case the satisfaction of the Board of Management to be recorded in the proceeding, it is not expedient to follow such procedure, the disciplinary authority may consider the circumstances of the case and pass such an order thereon as it deems fit. Now, my humble understanding is, my lord, all that the rule mandates is that the Board of Management must record a satisfaction that in the facts and circumstances of the case, it is not expedient to follow the procedure prescribed in Rule 88. Now, my lord, to appreciate the case, first of all, lordships will kindly consider it is not a case where the university is trying to find fault with him because he has committed a misconduct. No. We are concerned with a stage which is prior to the recruitment.
Those are facts. We can go into that.
My
But
lord,
the question
no, my lord,
here is,
to appreciate the legal position,
I got
we must apply the facts.
I got it. We'll
Yes.
get to that. But if we understand 3 in its proper perspective,
Yes.
there is no requirement in such circumstances to involve the petition.
No,
Because
no, my lord, because the division bench as well as the Supreme Court has said, now when the Supreme Court says you also apply the rules of 1919, so long as far as the division bench is concerned, my lord, there was no difficulty. Now, because Supreme Court has said you also apply the rules of 219. And kindly mark, my lord, say Rule 94 starts with a non-obstante clause. It overrides 88.
so it overrides the provision for an inquiry.
Exactly.
So if you read 2,
yes,
2 is reasonably impracticable to hold a inquiry.
No, those situation is not present. Therefore, 2 cannot be invoked.
No, but you have invoked.
No, we have
Your board
invoked
has
3.
invoked.
We have invoked 3.
No, your board has
No,
invoked.
no,
Yes,
my
yes.
lord. No, kindly
has
come to the
invoked.
order. No. Please come to the order.
Where is that?
At page 285. Please come to page 286. We have not invoked 2. Please come to page 286. After threadbare discussion over the matter, the following resolution was adopted. Resolved that considering the provision cited in the so-and-so employees academic rule 2019 and also pertaining to the division bench judgment and order dated 22/4/24 as well as SLP dated 21/11/25, the Board of Management in the context of the relevant peculiar facts and circumstances and in the interest of university is satisfied to recommend a special procedure of hearing as per Rule 94(3). As regards to the explanation reply from Professor Jayanta Kumar Sharma, in view of the reconstitution of the committee and for that purpose, in pursuance of the decision of BOM, will kindly appreciate one thing. Their grievance before the Honorable Supreme Court was that they have not invoked the Rule 88. Supreme Court has dismissed the SLP. Their grievance before the Supreme Court was, I am entitled to protection of Article 311(1) in letter and spirit, which was denied by the Supreme Court. When the Supreme Court says, according to conduct rules of 2019, whatever provisions is there, that will govern the case. And it is not a case where we are trying to find fault with any misconduct. Here we are trying to find out that his appointment was irregular. I am relying on...
Okay, where is the reasoning?
My lord?
Where is the reasoning? Satisfaction of the...
And in the interest of, he is satisfied to recommend.
But that will not do. There has to be some reason basing on which that the satisfaction is drawn.
No, my lord, it is in the interest of university. What is the interest of university? A person who has a PRO in NF Railway, he was appointed as a professor. Kindly see, my lord, there is an inquiry report. Kindly come to the inquiry report.
No, we'll come. We'll come. To Mr. Chaudhary, just
Yes.
for my understanding.
Yes. The reasoning is at page 284, my lord. In the
284.
same, my lord, the document, page 284, last paragraph.
It would be relevant to point out there that since the instant matter is concerned with violation of so-and-so, read with so-and-so, and that it is not concerned with imposition of any penalty as incorporated in the aforesaid so-and-so, it is rather concerned with cancellation of appointment, and that in view of the context of the aforesaid so-and-so, BM sees that following relevant provisions. Yes, absolutely.
But where is the show cause?
Show cause is the earlier one.
That is the one which is continuing.
Yes.
Where is that show cause?
Yes. This one,
13 book.
show cause is at 39, Miller.
Page 13.
102, 102, 102.
39 kon kya got?
102.
102, another, my lord, page 102, your lordship will find.
in pursuance of the judgment dated division bench and subsequent submission of the Board of Management,
Earlier show cause.
I
Where is three,
hereby direct to inform you to furnish your explanation.
Where is 3-4?
Yeah, page 39, my lord.
Page 39 is the, my lord, that is the.
Actually, university wanted to examine his eligibility as a professor.
Which they cannot.
Lord, you say cannot, but up to the extent of Supreme Court, it has not intervened in your favor.
Chaudhary, if that was the intention, that his initial qualification was doubtful, why did you go for such a big process in the initial stage itself?
Milord,
That led to proceedings before this
let,
court.
let me answer.
hearing-
Let me answer to your lordship's query. Milord, in administrative law, the authority has power of review. Supposing a man is appointed, milord, irregularly, can't the administration correct
That's
it?
what I said.
Yes.
Why did you then not make it a simple
No,
procedure
because,
to that
because
extent?
the VC was of his choice. When he was appointed, his comrade VC was in office. That's why we could not.
Where is the show cause?
Yes.
Came on the, my lord, there was a subsequent VC, my
Show
lord.
cause.
Show cause is 39.
39. It's not a show cause, my lord, they asked for the opinion. Your lordship will.
Milord, matter is very simple. You have understood the case. It is not that you have, it is not intelligible. It is intelligible to you. That's why you say you follow the procedure under article. The point which involves in this case is whether this explanation is enough or article 311 in letter and spirit is to be invoked. That's the only point, Milord.
So, Mr. Chaudhary, there is no departmental proceeding instituted.
No.
Till now.
Now, your lordship will kindly see the reasoning that I had pointed out, my lord, page 284. Your lordship will kindly peruse it once again, my lord. They want to give a go by because, my lord, 94 is notwithstanding, my lord, rule 88.
But
Rule 88, my lord, does not provide for the procedure. Procedure is 90.
Mr. Chaudhary,
my lord.
Rule 88 proceeding was never instituted against you.
No, proceeding under 90 was not initiated. my lord.
Initiated. So there was no proceeding under 90 which against you.
My lord.
Now, what is happening is that all these things are based on 3/4/2023.
My lord.
2 rounds of litigation. One went to the Supreme Court, another in the single judge. Now, in the subsequent single judge judgment, these aspects were before this court.
Yes.
My lord.
This court then limited that first thing that I asked you to 2 paragraphs, that this would be the committee, and the committee will now go ahead and examine your reply and your educational
My
qualification.
lord.
This court did not allow or did not direct that it should be by following 90.
True, my lord. Now, my submission with your lordship will, my lord, to understand the chronology of events, my lord. The judgment of the honorable single judge came pursuant to the, my lord, order of the division bench. In the meantime, we approached the Supreme Court.
Supreme Court is just an observation. We cannot
My lord,
read it divorced of the facts.
no, my lord, my submission is, my lord, Supreme Court in clear terms said, my lord, although the language, my lord, with all respect, they say do not interfere, but then there is a direction that you follow the UGC and the, my lord, service rules. That observation is there, my lord.
That is subsequent to the second writ petition or before the second writ petition?
Subsequent to the second writ petition.
But the
my lord,
second writ petition,
the order of the, my lord, subsequent writ petition, that is a, my lord, following the writ appellate's order, my lord, and the, my lord, that has merged with the, my lord, Supreme Court's order. Therefore, they have to follow the rules. Now, the question, my lord, notwithstanding what is there in, my lord, 88, because, my lord, 88 prescribes penalty. Now, your lordship will kindly read again, my lord, 284.
Okay. What they do. Mr. Chaudhary, you proceed with the matter
Yes.
by the committee, but don't take a final call till the next day.
My lord,
Come
my
with your-
your lordship will kindly peruse once again, my lord, for a while, my lord. They have already pre-decided, my lord. They say we are not going to impose the penalties under the Rule 88.
They are only examining
They say,
whether
my
you
lord, your lordship will kindly allow me to read it, my lord. Your
I
lordship
have
will
seen
kindly.
it, Mr. Chaudhary. We are not permitting them to take any final action against you.
My lord, your lordship, it is on Monday, my lord. Your lordship will postpone it for a while and thereafter decide.
No, let the committee go ahead. But the committee, you also participate without prejudice to your claim here, but participate, and thereafter let us see whether 90 has to be followed in such cases. If
My
we
lord,
come
they
to a
have already
conclusion,
decided, my lord, if your lordship peruses once again, my lord, they have already decided that this is not a penalty, we are cancelling appointment. That has also
Mr. Chaudhary, we are not permitting them to pass final orders against you. We are not permitting them. I'll make it absolutely clear here. But I am bound by the earlier writ petition. Now, how that will, the Supreme Court judgment will have an effect on this, that we will examine.
My lord, my submission once again, my lord, at the cost of reputation, they have prejudged the issue, my lord. They have decided to.
Mr.
My lord,
Chaudhary,
that
we
decision is very
accept
clear, my
everything.
lord.
We accept everything.
My lord, does it, my lord, fulfill 94 too?
That's the specific question I put to Mr. Chaudhary.
My lord.
And that is the issue which we have to decide. Whether in the fact situation, a proceeding under 90 is called for. If we hold that it is a proceeding under 90, then all these things will become infractions. But Mr. M.K. Chaudhary, Learned Senior Counsel, assisted by Mr. M. Sharma, Learned Counsel for the petitioner. Also heard Mr. K.N. Chaudhary, Learned Senior Counsel, assisted by Mr. T. Kashyap, Learned Standing Counsel, Learned Counsel appearing for the Krishna Kanta Hendik State Open University Authorities. Also, the grievance of the petitioner in the present petition is with regard to the constitution of a committee for consideration of the qualifications of the petitioner for holding the post of
Professor Bhupendra's School of Mass Communication.
Professor School of Mass Communication in the respondent number 1 university. The petitioner is also aggrieved by the recourse taken by the board of management of the university, respondent number 1 university, to take recourse. Petitioner is also aggrieved by the resolution adopted by the board of management of the respondent number 1 university in its 85th meeting to take recourse to the provisions of Rule 94 bracketed 3 of the rules of the service rules of 2019 for the purpose of determining the eligibility of the petitioner to hold the said post in the university. So, the Learned Counsel for the petitioner has submitted that the petitioner, being a confirmed employee in the university, even if it is to be considered as to whether the petitioner had the requisite eligibility criteria to hold the post of professor, School of Mass Communication, a proceeding under the provisions of Rule 90 of the rules of 2019 was mandatorily required to be so instituted. In support of such submissions, the Learned Counsel, the Senior Counsel for the petitioner, has relied upon the observations made by the Honorable Supreme Court. Page
164.
164.
Supreme Court in
165.
Supreme Court in the case in civil petition number SLP bracketed C number 53620/2024. White order dated 21/11/2025, wherein the Honorable Supreme Court had directed that the disciplinary proceedings be completed, disciplinary proceedings against the petitioner be completed in accordance with law, being UGC Regulation 2018 and Service Rules 2019. Accordingly, it is submitted by the Learned Senior Counsel for the petitioner that the recourse taken to the provisions of Rule 94, bracketed 3 by the Board of Management of the university is clearly not permissible. Per contra, Mr. K.N. Chaudhary, Learned Counsel for the petitioner, by placing before this court the background leading to the proceedings presently instituted against the petitioner, has submitted that what is being examined by the university is not a misconduct committed by the petitioner, but is the question as to whether the petitioner has the eligibility criteria for being recruited as professor in the university Also, it is submitted that the said issue unfortunately was not examined in its proper perspective while the petitioner was initially appointed. However, the same coming to the notice of the respondent authorities, the Board of Management had proceeded to consider the said issue. It is submitted that the provisions of Rule 94, bracketed 3, was at stands attracted in the case on hand, and in terms thereof, the committee now constituted in pursuance to the directions passed by this court, while the judgment and order dated 16/10/2025 passed in WPC number 4544/2024 would be required to examine as to whether the petitioner fulfill the requisite eligibility criteria for being appointed as professor. It is submitted that the provisions of Rule 94 bracketed 3 does not mandate extension of a hearing to the delinquent in the matter before taking a decision therein, but considering the directions passed by the division bench of this court in proceedings involving the petitioner and the university, as well as why the said judgment and order dated 16/10/2025, the committee as constituted in the matter was directed to afford all reasonable opportunity of hearing to the petitioner in the matter. Also, on a consideration of the rival submissions of this, rival submissions made by the learned counsel for the parties, this court is of the considered view that the issue, this court finds that the issue arising for consideration by this court is as to whether a departmental proceeding under Rule 90 of the Rules of 2019 is mandated to be instituted against the petitioner, and therein by affording to him reasonable due opportunity of hearing, a conclusion to be arrived at as to whether the petitioner was appointed in the university after his qualifications were duly verified and found to conform with the eligibility criteria prescribed for the post in question.
My lord, in the UGC regulation.
Order. So, it is also, this court also notices that the petitioner upon his, after his initial appointment on probation was confirmed in his services. Accordingly, a question would also arise as to whether a regular employee can be removed from his services without taking recourse to the provisions of Rule 90 of the Rules of 2019. Also, the said issue, a decision on the said issue would also require this court to consider the resolutions adopted by the Board of Management of the University to proceed in the matter against the petitioner by taking recourse to the provisions of Rule 93, bracketed 3 of the Rules of 2019. Also, the said issue would mandate, the said consideration would be permissible to be so made after the respondent university has brought on record its stand by way of filing an affidavit. Also, Mr. Kashyap, learned counsel assisting Mr. K.N. Chaudhary, submits that he be granted 4 weeks time to file an affidavit in the matter on behalf of the respondents. Also, with considering the balancing the equities in the matter, this court permits the respondent university to proceed against the petitioner in the matter through the committee as constituted by it. The petitioner is also directed to appear before the committee and to place before it his stand in the matter, including objections with regard to the procedure adopted for examination of the issue involved as to whether he is qualified to hold the charge of post of professor in the university, after he was so confirmed against the said post. The committee shall proceed with the matter and arrive at its conclusions, which shall be kept in a sealed cover. The conclusions of the committee shall not be given effect to without leave of this court. Also, the university authorities shall invariably bring on record their stand in the matter by way of filing an affidavit by the next date of listing. Also, accordingly, registry to list this matter again on.
So it will go to June, Miller.
Yeah.
First week of June, Miller.
Fine. Let us have it on 8th.
Yes.
Let them,
8/6.
let them file the affidavit a little early so that I can.
No, I'm giving you.
Yes,
They
we can
said
file it
affidavit
early.
be filed on or before 1/6/2026.
Yes, yes.
Registry to list this matter again on 10/6/2026. The petitioner is at liberty to file a rejoinder to the affidavit filed by the respondents, if so advised.
Deep level.
Highly obliged.
I think that takes care of both.
It's a very interesting case.
It will be. Because
It will
Mr.
be
Chaudhary, I still have my
the,
doubts.
because of the line used by the Supreme Court.
I still have my doubts with regard to the extent of your power under 94(3). It's an extraordinary
No,
situation.
my lord, my humble submission
Because you'll have
would
to go
be,
to second proviso.
what I will elaborate at the time of final hearing would be, my lord, natural justice has to be given a meaning
No,
in the facts of its own case.
Mr. Chaudhary, that is my,
Yes.
that's my issue. That's still troubling me.
Uh-huh.
Second proviso to Article 311(2) is basically what is there in
Like,
94.
there are two judgments of the Supreme Court. I have brought it, my lord, where Supreme Court had dealt with more or less similar situation.
What is
It
that
does not,
decision?
my lord, that Krishna Yadav and Chakradhar. Where Supreme
311(2).
Court has said, my lord, this is not a DP. This is a proceeding to find out whether the appointment was regular or irregular.
But going by the traditional school of conservative school of thought.
Yes, yes.
Conservative
Normally, the belief would be 311 is attractive.
No, the normal conservative school, once he is confirmed, then even if it is a misconduct prior to recruitment, this will be something prior to recruitment.
Palak Modi has slightly taken a different stand, my lord.
We'll see.
My lord, I have also.
It's a very interesting.
My lord, I have also, I'll argue on that, my lord, malice in law and malice on file.
Fine. Sure. You can even bring in Jay Jalika's judgment on that. Fine.
Obliged, sir.
But here I am just saying that his interest is not, your interest is not
I'm ready to
prejudiced,
say proceeding.
but at the same time, the procedure that the college had taken, if we hold it
Whether
to
it
be
is so abhorrent.
proper,
Whether it is so abhorrent.
to be proper, then the university is also not prejudiced in taking further.
Yes.
That much we have balanced.
Lordship has balanced the equity.
But I have this doubt still about 94(3). One of you.
I could not file the affidavit. On Monday, I am filing. On 15 maybe.
On
taken back.
Mr. S. Nath, learned counsel for the petitioner submits that the affidavit on behalf of the respondent is ready, of the petitioner. Affidavit in reply on behalf of the
Ready.
petitioner is ready and would be filed on
Monday.
Let it
on
be
11/5/2026. Accordingly, he prays that the matter be taken up on
15. Old matter, maybe 15. Only being to some record, some dispute. Some
on 15/5/20.
Diploma.
14/5/2026.
My lord, sorry, my lord, 14.
Then
I'll be out of
19/5/2026.
19.
19/5.
Okay.
But you have a very tough, big, steep hill to
Yes,
climb.
yes, my lord.
Very steep hill.
My lord, but I have some judgment I will produce.
Oh, judgments cannot
Length-
be DOC
Length of
facts.
service, one thing, my lord. I'll appreciate.
Yes. Yes, what has happened? Has it been forwarded? What has happened?
I have given one instruction, my lord. That is now pending in the personal department, my lord.
forwarded the personal problem.
Your lordship, after this development. Personal opinion.
The learned counsel for the respondent submit that the matter pertaining to consideration of the case of the petitioner is presently, for appointment on compassion grounds, is presently pending consideration by the respondent authorities. Accordingly, it is prayed that the matter be taken up again on 22/5/2026, on which date the learned counsel for the respondents shall apprise this court about the developments taking place in.
But I'm sorry, my lord.
But Mr. Das,
My lord.
Mr. Das, once you take a decision in this matter in favor, after the death had taken place somewhere 2 decades back, and the matter comes before me, you know what I'll do. Yes.
But in this, my lord, I have received the parawise yesterday night, my lord. Lordship permits me, I'll file my affidavit on Monday, my lord, morning.
Which one? Even,
Item number 4.
Oh, Millie.
Millie.
Yes.
My lord, I've received.
File affidavit.
I'll file it on Monday, my lord, morning, my lord.
Mr. B. Kaushik, learned counsel for the respondent. Learned standing counsel, Department of Learned Standing Counsel, Elementary Education
Elementary.
Department submits that there is no elementary education department now.
Director is there, my lord, Department of School Education.
Department of School Education. Correct me this. We should put it as school.
Yes.
Education. Department of School Education submits that the affidavit in the matter on behalf of the respondents represented by him would be filed on or before 14/5/2026. He prays that the matter be taken up again on 18/5/2026. Prayer accepted. Raised it to list this matter again on 18/5/2026.
Grateful, my lord. All right.
None appears for the petitioner, for the applicant on call. Raised it to list this matter again. For the ends of justice, raised it to list this matter again after 2 weeks on date to be fixed by. This is a covered case.
It's a covered case.
So we'll ask them to follow. There is an interim order here. The proceedings are continuing.
They will take a call, my lord, as per the decision, my lord. In terms,
Mr. H.
in terms of
Learned counsel for the petitioner. Also heard Mr. D. Nath, learned senior government advocate, appearing for all the respondents.
my lord, yes, my lord.
Appearing for all the respondents. The petitioner in the present petition has assailed the report of the one-man inquiry commission headed by one-man inquiry commission constituted for inquiring into the conduct of examinations by the Assam Public Service Commission and also the affairs of the said commission. The petitioner has also assailed a show cause notice dated 30/11/2023 issued by the disciplinary authority basing on the report of the one-man commission. The petitioner has further raised a grievance that immediately after issuance of the said show cause notice dated 30/11/2023, without affording to him an opportunity to submit his written statement, the authorities had appointed by an order dated 1/12/2023 a inquiry officer as well as a presenting officer in the matter, which is contented to reveal reveal that the matter has already been prejudged. So, the learned counsel for the parties have submitted that the issues arising in the present writ petition is covered by the decision of a coordinate bench of this court in the case of Oichoj, spell AOICHAR. Please know it to judgment to Belek case. Oichoj Jiban Borua versus State of Assam and others, judgment and order dated 1/4/2026. In WPC number 1380/2025. Also, it is submitted by the learned counsel for the parties that the directions passed in the said judgment would also squarely apply to the present writ petition. And Mr. D. Nath has submitted that the respondent authorities, even in the case of the petitioner hearing, shall act in compliance with the directions passed by the coordinate bench of this court in the case of Oichoj Jiban Borua. This court has produced the judgment and order dated 1/4/2026. Produced the decision of the coordinate bench of this court in the case of Oichoj Jiban Borua and finds that the conclusions reached therein are squarely applicable to the facts arising in the present proceeding. The coordinate bench of this court in the said decision had issued the following directions. Yarpra, page 175. Kita lagi boleh muka sih. Para 13 only, plus 13 only. Baki other two are not required. No, 14 and 15, because there is no interim order in yours. No. Also, the present writ petition is disposed of directing by applying the directions as extracted herein above, passed by the coordinate bench in the case of Oichoj Jiban Borua, and the respondent authorities are directed to apply the same to the case of the petitioner and proceed against him in the matter, in the disciplinary proceedings so instituted accordingly. Yeah. With the above observations and directions, the present writ petition stands disposed of. If you don't get it today, tomorrow you will have it on Monday. Right.
My lord, the college authority has sent the recommendation proposal, my lord, and it has been received by the department. However, no decision was taken at that point of time. In the meantime, my lord, the petitioner filed this case and there is an interim order. My lord. That's why the decision could not be taken. And the decision which is taken, but that is been brought into the record by way of affidavit, my lord, in our affidavit, that this proposal cannot be approved since he has been awarded 15 marks in contravention of the OM, my lord.
Okay, give it a copy to Mr. Chetri. Let he has to understand this.
Well, that has been already, I have challenged. No, my lord.
Mr. Das, S. Das, learning counsel for the petitioner, has placed on record the resolutions adopted in the matter by the governing body of the college in question, and submits that before the same could be approved by the departmental authorities, the petitioner had approached this court and on account of the interim orders continuing in the matter, such consideration was not extended to the petitioner hearing. Right? That's the case. That's the case.
It took some time to consider the case. In the meantime, the petitioner filed this case.
So there is no rejection till now.
No rejection, my lord, because since this case is pending, my lord.
You have not taken a call.
No, we have not taken a call in that manner, my lord, but in our affidavit, we have stated that this recommendation could not be approved.
Oh, so while the set position has been highlighted by Mr. Das, the respondent authorities in the affidavit filed in the matter.
Para 10 of our affidavit, my lord. Page 62.
You said she is entitled.
No. Could not be entertained, my lord. Para page 62, page, para 10, my lord. Page 62, the deponent requested that thereafter it was come to the knowledge of the deponent that the selection committee
Submitted that the petitioner cannot be held to be a selected candidate in as much as the marks given to her for the experience criteria were so awarded in clear violation of the guidelines holding the field. So, the said aspect of the matter would now require a detailed consideration by this court. As agreed to by the learned counsel for the parties, a registry to list this matter again on 29/5/2026. Registry to list this matter again on, it was in 29/5 as a top of date. No, admission, for admission. I couldn't like it.
For
29.
For disposal of. For disposal of.
It's naturally, now nothing is left. If it comes before me, take it that it will be disposed. Under court, I cannot force. Yes. Madam Bora, why was he called again?
One copy of the letter, Lordship, I have received 656, addressed to the superintendent GMCH to verify her disability.
So why did you then issue that certificate?
She also has some instructions.
No.
She was not verified by the Joint Director of Health Services at that time. Certificate not issued by the respondent 7 is not.
Now she want to examine.
Okay.
But certificate is fake, madam.
Yeah, interfering. Because that certificate is fake.
Yes.
And if you, the further examination, your case is found to be genuine, in future recruitments, you will be considered. You're not working now.
It's not issued by the Joint Director.
You're not working now.
She's working, but I have instructed her she is supposed to submit resignation, Lordship.
That fortifies the view. But Mr.
Page 31 kindly see, my lord. Petitioner before all Lordship got the highest mark, my lord. Page 31 kindly see.
We are not appointing you.
Petitioner got the highest mark, my lord. Page 31 kindly see, my lord. Because of the certificate, my lord, she got the appointment, my lord. Page 31 kindly see, my lord.
No, we are not appointing you.
62, my lord.
We are
And
not.
she got, my lord, 41. Page 31, merit list.
But Mr. H.R. Amit, learned counsel for the petition, also heard Miss M. Bhachaji, learned, M. Bhachaji, learned standing counsel, learned additional senior government advocate, appearing for the respondent number 1, 2, 3, 4, 5, 6, and Miss M.S. D. Bora, learned standing counsel, Health and Family Welfare Department, appearing for the respondent number 7. The respondent, Mr.
M.I. Hussain, Lordship.
M.I. Hussain, learned counsel, represents the petitioner, respondent number 8. The petitioner, along with the respondent number 8 herein, had applied for engagement as Anganwadi helper, right?
Yes,
In Posim Torangapur Tiniali Anganwadi Center in pursuance to an advertisement made on 1/11/2024. Both the petitioner as well as the respondent number 8 were shortlisted for appearing in the inquiry in the selection. Also, on conclusion of the selection process, the respondent authorities in the comparative statement so preferred, proceeded to show the respondent number 8 herein as to be the candidate recommended for engagement as Anganwadi helper in the said Anganwadi center on the ground that the respondent number 8 was a person with physical disability. In the comparative statement so prepared, it is seen that it is the petitioner who had secured the highest marks. Also, the petitioner being aggrieved with the selection of the Anganwadi, selection of the respondent number 8 as an Anganwadi worker, had approached the respondent authorities and by way of filing representations, and therein had questioned the disability certificate produced by the petitioner in the matter and had projected that the same was a fake one. Also, it is seen that thereafter the matter was examined by the authorities and the matter on being placed before the Joint Director Health Services, Gwalpara, it was clarified that there was no record maintained with regard to issuance of a disability certificate in the name of the respondent number 8, while registration number 183/2021 dated 26/2/2021. Also, the said position is further highlighted by the respondent number 7 by way of filing an affidavit in the matter, in the present matter, wherein also it has been reiterated that the PWD certificate produced by the petition, respondent number 8 is a fake one. Also, the counsel for the respondents have also not disputed this said position. Also, in view of the above, the very basis for recruitment of the engagement of the petitioner as an Anganwadi worker in pursuance to the advertisement dated 1/11/2024 to be found, having been found to be based on a forged document, the said appointment of the petition of the respondent number 8 as an Anganwadi helper in Pasim Tarangapur Tiniali shall not be permissible to be continued any further, and accordingly the said appointment stance interfered with. The respondent authorities are at liberty now to proceed against the petitioner to recover the wages as drawn, the honorarium as drawn by the respondent number 8 in pursuance to being appointed in the as Anganwadi helper in the said Anganwadi center basing on forged documents. In the event the amount is not repaid by the respondent number 8, it would be open to the departmental authorities to institute appropriate proceedings before the before the civil court of competent jurisdiction for recovery of this said amount. Also, the appointment of the respondent number 8 having been interfered with by this court basing on the fact that she did not have the requisite eligibility criteria for being considered to be a candidate offering a candidate belonging to the PWD category, it is found that the said appointment of the respondent number 8 is interfered with effect from the initial date of her such engagement. Accordingly, the petitioner herein being placed at serial number 1 in the selection process, the petitioner is directed to approach the director, Child and Women and Child Welfare.
Women and Child Welfare.
Women and Child Welfare, Wi-Fi filing an affidavit. In view of the above, the petitioner being placed at serial number 1 of the set in the connected selection process, the Director of Women and Child Development is directed to verify the said fact, and in the event the petitioner is found to have been recommended at serial number 1 by the selection committee to proceed to issue to the petitioner appointment order appointing her as engagement orders, engaging her as Anganwadi helper in so and so Paschim Torangapur,
Yes.
Anganwadi Center under Joleshwar ICDS project within a period of 2 months from the date of receipt of a certified copy of this order.
Obliged. Okay.
We are supposed to file an additional affidavit.
On the prayer of Mr. R. Dot, Learned Council for the.
This is gone for vetting.
You're for?
For
Which
PWD, my
Huh?
lord. PWD, my lord.
Standing Council, PWD. Matter stands adjourned for 2 weeks to enable the respondents to bring on record an additional affidavit. Also, registry to list this matter immediately after 2 weeks from today. Immediately on conclusion of 2 weeks.
My lord.
Happy your lordship. This is a case of dismissal from service after retirement. After 21 years of
All pleading complete.
pleading complete, my lord. But the petitioner is
It is stated in that the pleadings in the matter is complete accordingly as agreed to by the Learned Council for the parties registry to list this matter again on 21/5/2026 for.
Leave your blessing.
My lords, I filed the rejoinder, but my lord, that is not on record.
The Learned Council for the petitioner submits that a rejoinder on behalf of the petitioner has been brought on, has been filed, however, the same is on record. Registry to list this matter again on when?
28, my lord. 28.
25/2026,
No, 28,
along with the said
28.
affidavit. Rejoinder filed by the petitioner.
Can we, my lord, 28?
20?
28.
28,
Yes.
28, 28.
Obliged, my lord.
Obliged.
Here, your lordship may allow me to see the records, fixed date of hearing, because as per the proceedings,
You have got the records?
yes,
My lord, I have got.
you may be allowed to see the records, your lordship may fix the matter.
But it's an expert inquiry. Mr.
Expert, that's why, my lord, we did not get notice. Statement.
How
of-
was that? Where is the inquiry report?
They said they have done.
My lord, several notices were sent to him, my
Yeah,
lord.
that's what
He
we-
delivered,
No,
he did not appear.
whether that there is a finding record.
Yes, my lord, it's there.
The earlier proceeding was there, that was dropped. And if they have taken into consideration that proceedings or not, we don't know. Whether any evidence
Page
has been recorded.
64, my lord, inquiry report, page 64.
Okay, third, Mr. B.D. Das, Learned Senior Counsel, assisted by Ms. K. R. Deca, Learned Counsel for the petition, and also Mr. E.P. New, Learned Standing Counsel. You are for Health and Family Welfare?
Yes, my lord.
Bora, DP Bora, Learned Standing Counsel, Health and Family Welfare Department. Mr. Bora submits that the records of the inquiry has been received by him. Also, the Learned Counsel for the petitioner, Ms. R. Deca, Learned Counsel for the petitioner, submits that she be granted access to the said records inasmuch as the proceedings were held ex parte against the petitioner. Mr. Bora has does not object to this said. Accordingly, the Learned Counsel for the respondent shall provide access to the records to the Learned Counsel for the petitioner. Accordingly, registry to list this matter when?
Next week.
Next week. Okay. List this matter again on 14/5/2026.
And in the 14 minute, can it be on 20? Next week, minute.
21.
21.
Public, my lord.
Now I can see. If there is nobody by your side, I can't see you, no? I should not see you. Yes. Readings are complete?
Readings are complete. Only because the retrospective promotions were effected by creating supernumerary posts and financial benefits were granted by notifications admittedly. However, it was not granted. Now, therefore, we filed a writ petition. The Accountant General raised an objection that the periods where.
Okay, we'll consider. It is submitted that the readings in the matter is complete. Accordingly, registry to list this matter when? You have got the main part, the other when?
Yeah, not.
Any date. Give me a date. Busy council.
Between 11th to 20th, any day.
Huh?
Between 11th to 20th, any day.
11 to 28.
No, 20. In between, any day.
Okay. On 19.
Right. Great.
It will be possible for the time being.
Oh, no time being today.
I have filed my affidavit, your lordship. It's on record.
You have filed your affidavit.
No, it's on
When?
It's on 30th of April, your lordship.
Oh, more before, much before. So I think we will now have to pay you something. Mr. G. Bodle, Learned Counsel for the respondent number 2 and 5 submits that an affidavit has been filed on behalf of the respondents represented by him on 4/5/2026. Also.
I'm not in this case, lordship.
Then you're not, it's okay. The petitioner is at liberty to file rejoinder thereto before the next date of listing, if so advised. Registry to list this matter again on 18/5/2026.
Inquiry report has to be submitted here.
Lordship, I have some instruction, Lordship. Lordship, actually 2 appeals were filed by the petitioner, Lordship, but the same was
Yes, where
actually.
is the decisions you want to rely upon? I think we have given you enough time here. Yes, what are the decisions you want to?
PM Tank and.
PM Tank, Ramlal and?
PM Tank to heavy, but PM Tank is not heavy.
That much only? Ending more. Where is the inquiry report? Third day, learning counsel for the parties at some length. Ms. M. Bhattacharjee shall submit that the inquiry report is not on record, I suppose.
So only finding is there, but statements are not. So
Okay, Lordship, I shall get it. Kindly allow
Submits
me
that
2
the
weeks
inquiry
time,
report,
Lordship.
Submits that the inquiry report would be furnished on the next date of this. According, registry to list this matter again on 3/6/2026 for further hearing.
3/6, Lordship. Deeply obliged.
Yes, provisional pension given.
Yes, it was sanctioned, my lord, in 30 April of this month. And regarding the arrears,
Mr. I. Bothakur, Learned Standing Counsel, Forest and Environment Department, Forest and Climate Change.
Environment and Climate Change.
Environment and Climate Change Department submits that by order dated 30/4/2026, a provisional pension has been authorized to the petitioner with effect from the date following the date of retirement. Following the date of his retirement till the final pension order is issued by the accountant, by the Office of the Accountant General bracketed A&E Assam. He submits that with regard to the claim of area salaries, the same is being verified and a decision thereon would be taken shortly. He submits that for the other issues involved, he be granted further 2 weeks' time to file an affidavit in the matter. So, Mr. M.A. Sheikh, Learned Counsel, does not object to the set prayer made by the petition, by the Learned Counsel for the respondent. Accordingly, registry to list this matter after 2 weeks, by which time the respondent shall invariably bring on record their stand by way of filing an affidavit. A copy of the order dated 30/4/2026 is kept on record and marked as X for the purpose of identification. Give him a copy.
Yes. One thing, my lord, the arrear period, my lord, that was with regard to Hamring division, petitioner working. So
You are Forest, you are covering everything.
My lord, they need to be impleaded, my lord. That is my submission.
You bring on record, we'll see.
Will be.
My lord, a date may be fixed, my lord.
After 2 weeks?
A date may be given.
Oh, you're
If
getting your
necessary, after
provision.
3 weeks, my lord.
3 weeks, after 3 weeks.
A date may be given.
2 weeks of date, 30 days. 6.
My lord, your lordship mentioned that affidavit regarding what, my lord?
Let them find. I wanted that provisional pension to be given to you from the date. You have got it now.
Yes.
Breathe free.
My lord.
We'll let them see. What about the areas?
My lord.
Let them find. Because the pension has to be now, proposal has to be now prepared. And that cannot be prepared
Area
without
is
that
also
period being regular.
huge area, my lord, 11 lakhs.
And
Lord.
my intention was that he should be kept at some comfort level.
That's
Now you get it. Wait for some time.
oblige.
May I please, Lordship? In this case, they're supposed to file affidavit, my lord.
Lordship, this matter, my lord, I've just been informed that the SAD is the main party here. Unfortunately, my lord, our name has not been reflected, nor have been
Registry
given a
to
copy.
reflect, registry to list this matter again on 18/5/2026, reflecting the name of the Standing Council SAD for the respondents. You give him a copy.
Lordship.
Deeply obliged.
I think Lordship may not take up this matter. Kindly perish the order dated 8/4.
8/4.
This court-wide order dated, this court-wide order dated 8/4/2026 had required the registry to list this matter before any other bench without me. Any other bench, full stop. The said order is reiterated and it is directed that the present matter be listed before any other bench without me, Munam to liquidity.
Next week, my lord.
What was this? How am I? Oh, ho, 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 ho.
My lord, on next Friday, my lord.
No, I can't. I can't even touch this matter.
Next week, my lord, on next week.
You come.
Obliged, my lord.
No, please, in last session, Lordship, some instruction was.
Please, Lordship, as part of last order, we are required to show the basis on the basis on what basis we are saying. Our letter only went on 6th. Even then, Lordship, the rules are here in the petition.
No. I want that. Why he has made. I want that.
Why he has
made that projection.
But in the rule, it is specific, Lordship.
It cannot be. The laboratory assistant cannot be promoted as assistant chemist. He will have to be a senior laboratory assistant.
Yes, a senior
Laboratory
technician.
And then only assistant.
Then only, yes.
But your director says that from this post you can be promoted as lab assistant chemist.
May I submit one thing? The next promotional post, senior laboratory assistant, there is a two post, two incumbents are there.
We'll come to that. But why did he make that? Why did he make that?
Then he himself has to.
You get it?
No, sir.
They are permanently disqualified for the assistant chemist, Lordship. Next, senior laboratory, those are there, Lordship. I am, my promotion is.
Further,
not
the
by
learned counsel for the parties at some length. Mr. C.K.S. Borua, learned counsel submits that he be granted time till 25/5/2026 to complete his instructions in terms of the query raised by this court by the order dated 4/5/2026. I accepted registry to list this matter again on 25/5/2026 for further hearing.
One thing, Lordship, the rule they have complied, Lordship, this rule is a draft rule, not a gazette notified rule. This is, department is not bound to follow this rule, Lordship. This is not under Article 309, Lordship. This is a draft rule, Lordship. Whether the DPC is bound to follow this rule, maybe.
Consider his case for director, post of director.
No, Lordship, this is my.
Disposing it off.
No.
Your case will be now considered for the post of director.
No, Lordship.
Because there is nothing.
The senior.
Because that is not there, the director can write anything. You be the director.
In this case, whatever next two post, Lordship, they are permanently disqualified for assistant commission. They are not qualified.
Mr. Hogg, that is not the ground projected. The ground projected is that you have a degree qualification. You are directly entitled to assistant chemist. And the author, every promotion is made on the basis of that draft regulation.
One line also.
On the next date, not next date.
Lordship.
If you are trying to be favored,
But
it should be done in a structured manner. And if I don't get it, I'm having your director next time. Not the one who has issued, the present one. Get that instructions. I want to understand what is the thought process.
Please, your lordship. Lordship, my senior counsel engaged in another court for the time being. I request matter may taken up.
What do you want? What do you want?
For the time being, lordship, my senior counsel.
The time being not possible. On the prayer of the learned counsel for the petitioner, register to list this matter again after a week on a date to be fixed for.
Published. Same rules.
Same. Charges have been framed. Framed.
Yes. We have filed the affidavit, and in the affidavit we have annexed that, no?
Mr. Das will consider this matter.
Lordship, my lord,
Not today.
I have got submissions, my lord, regarding his plea taken in the affidavit.
Oh, fine. We'll hear
Yes,
it.
my lord, yes, fine.
Now the proceedings are state.
Proceedings are state as of now.
As the pleadings stated in that the pleadings in the matter is complete. Accordingly, register to list this matter again on 21/5/2026. Admission hearings.
May not be on 21.
When?
Lordship may prepone.
19?
Lordship may not be inclined to prepone, my lord. 21. Digdari as 21. After that law.
22?
No, my lord, not 21, 22, I have.
26?
26.
26, my lord. 26. The interim may continue.
Interim order passed earlier to continue till the next date of this.
Lord.
My. Hello, yes.
Problem.
May I please then also. Lordship may kindly go through the order dated 2/4/2026, Lordship. Mr. I. Thakur was supposed to place to apprise this court about the present status of the case. Lordship.
Patilana counsel for the petitioner. None has entered appearance on behalf of the respondents. However, for the ends of justice, registry is directed to list this matter again on 22/5/2026.
Lordship, on the last occasion, they were also absent. Lordship.
Okay, I am drawing up contempt proceedings. You argue. What is the violation? What is the order?
Lordship may kindly come to the order dated at page 12, Lordship. Is there, Lordship. Page paragraph 6, Lordship.
Then what did they do?
They have stated that Lordship may kindly come to page 15B, Lordship. Last paragraph, Lordship. As showed above.
Yes.
Yes, my lord, it is pending consideration by the finance department. My lord, I was
You
informed.
have considered it. You have done your considerations.
Yes, from our.
Yes, what is left to be done? What is the
Okay.
violation now?
Lordship, the direction was that they has to consider my case and if found eligible,
They
Lordship.
cannot do it. They'll have to do it by the finance department. Is finance department a party
Yes,
here?
Lordship.
No.
Finance is not a. The Telangana counsel for the petitioner submits that he be granted 2 weeks' time to file an application for impleading the respondents in the finance department who are now presently, who are required to now accord approval for compliance. Time for 2 weeks to file an interlocutory application for impleading the respondents in the finance department in the present contempt petition. I accepted registry to list this matter again after 2 weeks on a date to be fixed by.
Obliged.
Hey, please, Your Lordship. Lordship, we have taken the steps to dust the service, Lordship. Upon respondent number 10, Lordship. I order dated 23/2/26, Lordship.
But where is the witness? There is no witness here. There is no witness. That you have effected service, that should be in presence of a witness. Yes. What about your affidavits? Okay, argue.
Lordship, to the petitioner, here is the legally wedded wife of the deceased husband, where.
You're the first wife.
Yes, Lord.
How do you establish that? You are Runu Soikya.
Runu Soikya, Lord. Lordship, I have legally, Lordship, the petitioner has a son, Lordship. Out of their wedlock, Lordship. It was their first marriage, Lordship.
Where is the, this we will not accept your, this one. This is by Runu Soikya, not by Runi Soikya.
The steps, Lordship.
Huh? The receipt is by Runu Soikya, RUNU. How can we know that this is respond number 10? Respond number 10 is Runi, RUNI.
The conducting counsel is out of station, but
Then
there
why
must
we
be-
wasted so much time? We are rejecting that. Take fresh steps.
we will take fresh steps.
Where was the
From my
affidavit filed by the petitioner pursuant to taking steps to dusty mode upon the respond number 10? On a perusal of this set, this court is not satisfied that the same service was effected on apostrophe Runi, R-U-N-I, Soikya. Further, such certificate is found to have been effected without the without taking the signature of the affected in absence of any witness for the purpose. Thus the affidavits have been shown to have been received by apostrophe Runu Soikya, which is again the petitioner in the present writ petition. Accordingly, petitioner, the non-counsel for the petitioner submits that he will clarify this issue and accordingly prays that the matter be taken up after 3 weeks prior accepted. Registry to list this matter again after 3 weeks on date to be fixed by learned counsel for the respondents. Learned counsel for the respondents. Learned standing counsel AG as well as the other as well as the government advocate are present for their respective respondents.
May I please, my lord, I'm sorry, my lord, item number 28 and 29, my lord, I was engaged in a
Cross.
hearing case, my lord.
Next time, next week.
Their student and their exam is scheduled on.
Can't help it. We were there. You should have been more. Last time also I condoned this. But this time we are not doing that every day.
On 15, their exam is going to help.
We can't help it.
Lordship may fix a date on 12th, my lord, to 11 or 12th, my lord. Their exam is on 15th, my lord.
On 11.
On 11.
No, 12, 5. 28, 29.
28, 29.
May it please your lordship. Lordship, pertaining to certain miscommunication error between myself and my senior, your lordship, I was instructed to pray for a week's time to file an additional affidavit, your lordship, if your lordship allows for it.
No, what is the error?
There was certain miscommunication between the senior and myself, your lordship.
But there is no what is the miscommunication? What is the error that you find in the judgment?
Your lordship, actually, this order, perusing the order, your lordship has certain paragraph 13 and 14 kind of look to me like there were certain issues there, your lordship, but
no, what is the error? Tell me that. It's a review.
your lordship. Your lordship, this does not specifically highlights what the order, the part where the
Okay, as prayed for by the learned counsel for the
lordship, just 1 week.
registry to list this matter again on site I get 06/2026.
Much obliged, your lordship.
As per the last order, we have taken dusty file affidavit today. However, the speed post lordship, speed post inadvertently we left out. Today we are taking it speed post. Otherwise,
On the prayer of Mr. B.P. Bora, learned counsel for the petition, registry to list this matter again on list this matter again after a week. Also, in the meanwhile, it is submitted that the petitioner shall bring on record the affidavit filed in pursuance to effecting service upon the respondent number 9 by way of dusty mode. It is further submitted that steps for service of notice upon the respondent number 9 by way of speed post shall also be taken within 2 days.
only today we are taking it.
Registry to list this matter after 4 weeks on a date to be fixed by.
Lordship, interim order is till today. The main interim order was to be considered today. Otherwise.
You take your steps. You are committing default. What can we do?
Lordship, we have filed the affidavit.
It's not on record.
Lordship, it's.
Today we can't permit that. Next time.
Lordship, interim order was still today, Lordship.
There is no interim order here.
Lordship, last line, Lordship.
Okay. The interim order passed earlier to continue till the next date of listing.
May I please, your lordship? Your lordship, we shall file the amended cost title, your lordship.
If you have not filed, you have not filed, but you were directed to file it.
Your lordship, some time will be allowed, your lordship, 2 weeks' time.
50,000 rupees. Just to file an amended cost title, this matter is pending from 2/4. We are 1 month down dealing. Why? They're not interested. Forget it. That's all. Yes, Mr. Chetri.
I am appearing on behalf of respondent number 10, my lord. Here, the Safekati governing body, Safekati College already.
Yes, this matter is already decided.
Yes.
Covered case, and I had thereafter dismissed one writ petition yesterday. I think the order was uploaded.
And respondent number 10, my lord.
Where is Mr. Sen?
Your lordship is on leg in another court.
Okay.
And very interestingly, my lord, respondent number 10 approached this honorable court and case was dismissed. Again, he has come before this honorable court without saying anything, no paragraph, nothing else. That has been suppressed. Now affidavit will be filed, my lord, on Monday regarding this matter.
You will file.
I will file.
On the prayer of Mr. P. Chetri, learned counsel for the learned counsel appearing for the respondent number 10, requested to list this matter again on 29/5/2026. In the meanwhile, it is the learned counsel for the respondent shall bring on record their respective stance by way of filing affidavit. And get that order, earlier order also.
Lots.
Much of
But Mr. M. Sharma, learned counsel for the petition. The interlocutory application. I-8 Marivade 1475. The present interlocutory application has been instituted, praying for impleading the opposite party number 1 hearing as respondent number 3 bracketed A in the connected writ petition being WPC number 2189/2026. This court has perused the contentions raised by the petition applicant in the interlocutory application and finds that the party sought to be impleaded is a necessary and proper party in the proceedings of WPC number 2189/2026, and accordingly, the present interlocutory application stands. Accordingly, the petitioner, the applicant is permitted to implead the opposite party number 1 herein, as respondent number 3A in the connected writ petition being WPC number 2189/2026. So with the above observations and directions, the present interlocutory application stands disposed of. But Mr. M. In view of the order passed today in WPC number 1475/2026, permitting the petitioner to implead opposite party number 1, implead so and so. Page 3, A2, 1 to Niribade, party number. As party respondent number 3A in the present petition, petitioner to file a amended cost title within 2 working days from today. Also, I've heard the learned counsel for the parties. Also, considering the nature of issue raised in the present petition, issue notice returnable 3 weeks, returnable 4 weeks. Also, petitioner to Mr. Learned, no, who is for 1? Mr. S.K. Medi, learned counsel, accepts notice on behalf of respondent number 1. While
I will just speak for my
you can appear for Labour Commissioner.
Yes.
While Ms. U. Sharma, learned Government advocate accepts notice on behalf of respondent number 2, 3, and 3A. 3A. Also, while Mr. Ad hoc Standing Counsel AGMCL accepts notice on the pro forma respondent number 4. As all the respondents are represented, also, pendency of the present writ petition would not be a bar for the competent authority to consider the application. It's called an application.
Application on the form N.
Application submitted in form N by the petitioner in the matter.
I'm grateful, my lord.
Please, Lordship, item number 38. Lordship, can it be taken up on Monday, Lordship?
38.
Yes, Lordship.
Oh, yes.
It will be only impeding.
But Monday is possible, 19.
19.
Tomorrow is holiday. Too difficult.
No, on Monday, Lordship.
Monday, tomorrow holiday, who will take the file?
Oh,
Signing and all will take.
that 12, Lordship, because impeding only.
Well, I gave it